Well, welcome to potentially the most unusual ThinkHouse special to date. You may be seeing before you a rogues gallery of experts pulled together to address some of the many issues falling out from the impact of COVID-19 and the government measures to address it. From this, you will learn two things: the depth to which the current environment is impacting people and business, and the sparkling range of wallpaper and wall colorings that our lawyers possess. Only be grateful that you can't see their pajamas. Fingers crossed, you've got a dangerous mix here of lawyers and technology, so that's a dangerous combination, so please be patient if the odd wheel falls off here and there. COVID-19 is a deeply concerning crisis of the highest order. People's healths and lives are at stake. And against that backdrop, legal seminars might appear pretty secondary. I'm proud to say that Gowling WLG is playing a role on the front line of the crisis, working with the engineering consortium, which is increasing ventilator equipment production, and advising the government on several key initiatives. Equally, COVID-19 is likely to have a major and at least medium-term impact on most of our livelihoods. And how businesses support their people and are managed through the crisis will determine the safe and secure futures of those people and wider society. As lawyers, we are right at the front of the careering bus as businesses seek to address and manage the risks to their and their people's futures, from securing safe and stable employment to maintaining and securing supply chains and preventing financial crisis and ensuring financial survival as we pull out of this. As Sufi wisdom has it, this too shall pass. Right now, the biggest issue facing many businesses is how to manage their people in this difficult economic environment. Usually a business's most valued asset, it is equally also its most costly. And businesses have to face a tricky balancing act between care and concern for their employees' lives and livelihoods, and hard-headed business calls to ensure there is business in which to work in the future. These are the issues which our employment partner, Jonathan Chamberlain, is having to grapple with. Its relevance to business highlighted by the fact that our webinar on the topic of furloughing, there's a new word, on Monday had over 400 attendees, followed up by over 200 questions. So, Jonathan, first question to you, please. The government job retention scheme is right at the top of employers' agendas. How does it work?
I think the basic outline of the scheme is now reasonably well understood. For businesses that make employees redundant, we'll come on to talk about which employees in a moment, then instead of a redundancy, the government will repay to employees, or reimburse employers up to 80% of the employees' wages. They will add on top of that the employer's national insurance contributions. They will also add on top of that the auto-enrollment pension contribution level. The idea being that the employees continue to have money in their pockets, they continue to remain employed, so that when the upturn comes, as Michael says, this too shall pass, then they can swiftly be rehired. So this is a social measure protecting society as much as it is individual businesses. Now, we don't actually yet know the full detail of how the scheme is going to work. We know that the amount of wages, salary remuneration the government will pay is 80% of the cap, £2,500, plus the other elements that I've talked about. But a lot of the detail that we would normally expect to see in regulation just isn't there. We've got some fairly extensive guidance from HMRC, and it's really interesting that this is being administered by HMRC, and I'll come back to that I hope, later in the presentation. But it's very hard for us to give definitive answers as to what this is definitely going to look like in practice. But the outline, I think, is reasonably well understood.
What then are the key things that employers must do to take advantage of the scheme?
Well, if I can start off by answering that question in principle, if you like, because I think it really helps to drive understanding of what's going on here. A lot of the questions that we're getting are about the implications of this for the employment relationship. And it's really important to understand that the government has not said very much about the implications for this for the employment relationship at all. This is if you like, a grand tax rebate scheme. Employers will have to apply through an HMRC portal to be able to get their money back. It's being administered through the PAYE system, which is why it's crucial to understand that in order to make a claim in respect of an employee that you've put on furlough, that's somebody for whom you've got a PAYE code up and running before the 28th of February this year, which is the cutoff point. New hires after that date won't count. And because this is all being administered through PAYE, it's very easy for the revenue to see whether someone is a new hire or not. Now, there is an exception to that, and this is a practical point. This is the first practical point that I want to make, which is that if you'd already made somebody redundant because of the impact of COVID-19 on your business, after February the 28th, but before this scheme was announced, then you can rehire them specifically for the purpose of putting them back on furlough. If you moved early, if you like, you can still take advantage of this scheme. What you can't do is bring in new hires and then put them straight on furlough. That's not going to work. So that's my first practical point, which is the 28th of February is a really key date here. My second one is this. If we were to go to an employee and say, hi, we're not going to give you any work to do, you remain an employee, but we're now only going to pay you what we can claim back from the government, which means 80% of your remuneration up to a cap of 2,500 a month, then in normal circumstances, an employee would turn around and tell us where to stick it, and or they would bring a claim for unlawful deduction from wages, because most employers will not have the unilateral right to furlough people. As Michael said, that's becoming a verb now. And the government has said nothing on this. They are leaving it to employers and employees either to invoke contractual terms which allow you to put people on furlough, and there are some manufacturers who will have those terms in their contract, but most people won't. Or it's a question of reaching agreement with the individual employee. Now, it's fair to say that most employees are pretty receptive to this idea at the moment, because the alternative to furlough is redundancy, and the whole point of the scheme is to avoid redundancies. However, it's not without complications. So there are some sectors, for example, where there are labour shortages, and it is anticipated there'll be labour shortages when the recovery comes back, where employees are demanding that the employer make up their full pay before they'll consent to going on furlough. So there are a lot of complicated issues to work out there. And that means that a key practical point is to record the terms of the agreement that you've reached with the employee in a document that you can later point to when the dust settles down on this, and we anticipate that HMRC will start challenging some of these furlough arrangements. They'll look to see whether they were genuine. They'll look to see that, for example, the employee wasn't simply being rehired in a temporary role or coming back through an agency. And it'll be important for the employer to demonstrate that this was a clean arrangement, that everybody understood that the employee was being put on furlough. They were to do no work for the employer whilst they were on furlough. And whilst they were free to volunteer, that's about as far as it could go. There is a question mark about whether people on furlough can work for other employers, but that would require looking at in individual circumstances. So I think those are the key practical points. this applies to anybody who was on payroll before 28th of February, that nothing in this affects the underlying employment relationship. The rules, such as they are silent on that, and that it's important to record the agreement with the employees in writing so we can refer to it later on.
You're very much in the eye of the storm at the moment, Jonathan. What other employment issues are coming up in practice?
Well, one of the ones I just mentioned was employees are wondering if they can go work for anybody else. Because, of course, in all of this, the supermarkets are still hiring. The delivery services are still hiring. The NHS is still hiring. And what we are saying is that the HMRC guidance isn't clear. It doesn't expressly prohibit that as an issue, or as an opportunity rather, but that the furlough agreement should at the very least provide that the employee tells their employer when it is that they are getting work for somebody else, that the employer has a right of veto over that, and indeed that right of veto extends to being able to say, I'm sorry, you've got to leave that new job or lose your furlough pay, if when the regulations come out they make it clearer that this is prohibited. So again, it comes back to making sure that that agreement is watertight. Other issues that are coming up are around holiday, where the rules are that holiday continues to accrue whilst people are on furlough. So that could mean that if somebody's furloughed for several months, they've accrued a lot of holiday, and they come back to work and they want to take that immediately, which is going to place a strain on the business at that time, or they want to be paid in lieu for it, and the rules on that are changing to allow carryover for up to 2 years. So there could be big bills being built up. Again, if employers don't operate the furlough properly, you can require employees to take holiday during furlough, but you have to jump through certain hoops to be able to do that. So those are the kind of things that are coming up, the sort of practical implications of working this out, the kind of questions that people are having. What does this mean for me?
Thank you, Jonathan. Health and safety is also a big issue, both in the context of employees, but also actually the other people we're responsible for, potentially the self-employed consultants we work with. Andrew Litchfield, you're our health and safety specialist partner. What legal liabilities in that field are there coming out as a result of COVID-19?
I think the first point to make, Michael, is that there's no new law as a result of the current situation we're in. What we do have, though, of course, is a big new risk, which none of us knew too much about even a few weeks ago, which of course needs to be managed and people need to be protected from. So we revert back, I think, to our basic overarching duty, which sits on every employer, which is to ensure, so far as is reasonably practicable, that its employees and anyone affected by what it does are not exposed to risk to their health and safety. So nothing new about that. That's the Health and Safety Work Act from 1974, and it's the basic overarching duty. Risk is the possibility of danger, so every employer has a duty to ensure, as far as reasonably practical, that people are not exposed to the possibility of danger, which of course is a challenge for everybody and for every business in the current climate. You can't contract out of that duty, and breaching it is a criminal offence by the employer. So there are two potential liabilities that you could face as an employer. First, that you could breach that overarching duty and commit a criminal offence as an employer, so a criminal liability. And second, you could face a claim for damages by an employee or by an individual based on that duty, but also in negligence, that you've exposed them to the virus negligently and they're entitled to damages as a result. But there are two other, I think, perhaps even more immediate reasons to manage the risks arising from the virus. The first is that you could suffer some brand damage, get this wrong, and we've seen some stories emerging over the last couple of weeks or so already of certain businesses being accused of mismanaging the risk, forcing people to work in circumstances which they're considered to be unsafe, and suffering brand damage and social media adverse publicity as a result. But there is a big brand driver, I think, to get this right and be seen, to be perceived to be managing it correctly. And then, of course, obviously, it's just the right thing to do, isn't it? To keep your people safe and to keep society safe and to stop the spread of the virus any further than it absolutely needs to do.
So what practical steps then, Andrew, can businesses take to manage these liabilities?
So in health and safety law, all roads very quickly lead to risk assessments. It's a statutory requirement to do a risk assessment anyway in relation to any of the risks which we might face in the workplace. And it's even more important to think about that from a COVID-19 perspective. That requires an employer to evaluate the likelihood of that risk coming about, the consequences of it if it does come about, as against the cost of eliminating it. And that's, of course, what everybody has been doing, the government is doing, and what all employers have been doing over the last few weeks in any event. It's the reason why we're all working from home. It's the reason why we're being instructed about social distancing, about PPE. All of these things arise as a result of risk assessments which are being done by all of us all the time, but perhaps more formally by employers. And it doesn't matter whether you're working from home as we are, or whether you're still in a protected occupation, so you're still working in the workplace. The importance of the risk assessment as a result of the COVID-19 risk is critical, and that will spew out measures to take to manage the risk, and it needs to be done task by task, individual by individual, job by job, to make sure that everything that could be being done is being done, and all the appropriate measures are being taken, whatever they are, in relation to the specific job in question. One thing that is worth mentioning, I think, is that we're obviously all currently preoccupied, rightly, with COVID-19 and taking measures to protect ourselves from the risks arising from COVID-19. But the risk assessment also needs to consider whether the protection measures arising from COVID-19 themselves might give rise to other risks, which they also need to be managed. So we're all working from home, for example. We need to be thinking about the display screen risks, the workstation risks, which might be resulting because of the fact that we're all now working in slightly different circumstances and away from our normal place of work. And that could apply on a construction site just as easily as working from home. So keep those, do a risk assessment, keep those risk assessments valid, and make sure that they consider other risks arising from the protection measures that COVID is generating.
That's obviously the situation now. Will these steps be likely to change as the position evolves?
Yeah, for sure. If you think back, if we all think back to what we were doing 2, 3, 4 weeks ago and what we're doing today, it's a huge change, and we are bound to learn more about the nature of the COVID-19 risk over the coming weeks, whether that's the result of further testing, whether it's the result of learning whether if you've had it you're immune for the foreseeable future, whether we learn more about how effective PPE is and how effective the social distancing is. So we will learn more. It's a statutory requirement to keep those risk assessments under review at all times. And it's just as the risk evolves, as we learn more about the risk, it's even more important to review those risk assessments and then take steps arising from the reviewed risk assessments. So I think we can expect everything to keep changing, everything to be kept under review, everything, even perhaps optimistically, as we start to lift restrictions, what effect will they have? The risk assessments need to take account of relaxing the rules just as much as they have about tightening the rules in the first place.
Thank you very much, Andrew. I mean, the term risk has been used a lot, and of course, every time you use the term risk, I always think of insurance. So I'd like to turn to Sam Holland, who's our insurance specialist partner. What are your sort of top tips really for clients to do when they're checking to see whether they're covered for losses for COVID-19 events?
So the first thing that clients need to be doing is digging out their policy documents as soon as possible. If necessary, checking with their insurance broker to see what cover they may have. And then they need to be reviewing those policy wordings really carefully, and where appropriate, think about getting a legal view on whether or not they're covered. It's not always that clear. If they're in any doubt at all, I would always advise that they make a notification to their insurers, even if it's just on a precautionary basis. They need to check that they're following any specific requirements in the policy as to the form of that notification and how they need to be making it. And then they'll have protected their position while they investigate their claim further. And the other thing they should be doing is gathering evidence in support of their claim, working alongside their brokers and their lawyers. If they can quantify their claim early, that might support an early interim payment from their insurers, and then that will lead to an important and an early injection of cash into the business at such a critical time.
Because a number of businesses have been required to close down as a result of what's going on. Will they be covered for business interruption under business interruption policies?
Well, unfortunately, Michael, in the vast majority of cases, possibly not. So typically, business interruption cover under a UK market standard policy is only triggered by physical damage to the premises. And even in circumstances where there are traces of the virus found on your premises, that's unlikely to constitute physical damage for the purposes of your insurance policy. Having said that, some businesses will have purchased extensions to cover, and there are two specific extensions that may help. They are firstly a denial of access cover, and secondly an extension to cover for a notifiable or communicable disease. But it's really important to stress that cover will depend on the precise wording of your extensions. So dealing with the denial of access clause first, that will typically provide cover for business interruption losses where a business is prevented by an order by the police or a government authority to close down your premises, which prevents you accessing your premises, usually in conjunction with some sort of threat to public health or a danger to life. So it might apply here, but those clauses were generally intended to apply to very localised incidents. So a typical example would be a terrorist attack, rather than a global pandemic on this scale. So insurers are going to push back. And the other thing that insurers might say is, well, you can continue to access your premises, you just can't trade from them. So the clause isn't triggered. The second clause I mentioned was the extension to cover for notifiable or communicable disease. Now that will provide you with cover for your business interruption loss where you've had to close down your premises as a result of a disease. However, some policies will generally have a list of specified diseases which are covered. And obviously COVID-19 being a novel disease, that's not likely to be in there. Other policies will cover a notifiable disease, and the good news is that COVID-19 has been a notifiable disease since the 5th of March this year. But other policies may also require you to show that someone has actually contracted the virus on your premises or within a certain distance of your premises. So that's another hurdle you may need to overcome. But in all honesty, even if a client is able to get a claim home under those extensions to cover, the limits are generally much lower, the excesses are higher, and they're still going to have to prove their loss. And that is another challenge for our clients, unfortunately.
Well, Sam, I'm not going to let you off that hook, actually. You've teed that up nicely. How is it that clients are actually going to prove their losses?
Well, it's not going to be straightforward. So some clients will be looking to claim their financial loss as a result of the impact COVID-19's had on their business. So that would typically include loss of profit, for example. Any such claim is going to have to satisfy the but-for test, which was set down by the High Court in the Orient Express case after the Hurricane Katrina. So that means that the business has to show that it would not have suffered the loss but for the closure of its premises, and not, for example, as a result of the issues affecting the wider area. So in other words, it's going to have to compare its actual position with the position it would have been in if its premises were open, but in circumstances where the rest of the UK population is socially distancing themselves from everybody else and staying at home. You can already see, Michael, how that's going to be quite difficult to do. Other clients, landlords in particular, are looking to see if they're covered for loss of rent. That will depend in part on the wording of their lease. If a tenant has the benefit of a rent cessor clause, which applies in a non-damage scenario, such as this, then it's possible that they will be covered if they can get their claim home under their extensions to cover. But if a landlord has just decided to grant a rent concession to their tenants, then that's not likely to be covered because it's not a fortuitous loss, it's just the landlord deliberately deciding not to enforce their strict legal rights under the lease. That then leaves us a really big grey area, which is what happens if your tenant just refuses to pay their rent and they're citing their inability to access the premises as a result of the COVID-19 restrictions as the reason for that. It's possible that some landlords might be covered for that scenario, but that will depend on the particular circumstances of each case and again on their precise policy wording. And we can expect to see quite a lot of disputes, I think, around that area coming up the track.
Presumably clients may also be facing third-party claims. What's the position there? Yes,
that's right. So most UK businesses will be maintaining public liability cover, which, as you know, is the policy that will provide them with cover in the event of third-party claims for personal injury or property damage. So that's the right policy to turn to, for example, if one of your customers alleges that they became ill and exposed the coronavirus on your premises. Cover, sound a bit like a stuck record, but cover again depends on the precise wording of your policy. Usually bodily injury is defined in those policies as including disease, but there might be limited cover for things like emotional distress. For example, if a customer alleges they're exposed to the virus on your premises and is subsequently found not to have developed COVID-19 as a result.
I'm just left wondering whether the modern alternative of a stuck record is a buffering download. I don't know, but how does a client protect their position if when it's coming up for renewal, if their cover's coming up for renewal?
Well, we're already seeing the impact of this. A lot of clients who are renewing their policies on the 1st of April are facing some challenging discussions with their insurers. So clients can in short expect some pushback. There's already talk of property damage and business interruption insurers trying to modify their denial of access clauses to make it clear that they're not intended to respond to global pandemics along these lines. And you can expect your liability insurers to try and exclude cover for COVID-19 claims. In addition, clients can expect to be asked more questions on renewal around COVID-19 issues, particularly those that are operating in the higher risk sectors, so health, for example, or retail. And one important point I wanted to make was if a client has directors and officers liability cover, which is the policy that provides it and its senior management with cover for claims made against its directors and officers, they'll need to check that that cover is up to date and robust as possible, bearing in mind that decisions that their management are making now around these issues may well ultimately be criticised at a later date by shareholders or regulators or insolvency practitioners. And I know we'll talk a little bit about directors' duties later on in this session. But in summary, clients need to use their broker wisely to leverage the best possible cover they can. It will be difficult if there's a whole market approach. And perhaps think about getting a lawyer to give their wording a once over and make sure they understand what it's covering them for.
Thank you, Sam. The lifeblood of most of our businesses in operational terms are the multitude of large and small contracts that keep their businesses ticking over day to day. Regular members of attendees at ThinkHouse will know the famous double act now of David Lowe and Andrew Smith, who bite large chunks out of each other as they debate contractual issues, usually on stage. I just wonder whether they're now a bit more remote. They might be a bit safer from each other now. But Andrew and David, and presumably now with COVID-19, all contractual bets are off, aren't they?
Thanks, Michael. I don't know how it appears on your screen, but I, for the first time in my life, can look down on David Lowe, which is always an advantage, I think. So the way we're going to deal with this is I'm going to deal with it from the sort of disputes and the risk side, and David's going to deal with it from the sort of contractual drafting side. So in answer to your question, I don't think all contractual bets are off. These are difficult times, but as with all English law contracts, you've got to read the contract. It's what the contract says. You need to look at what your obligations are and then fit them to the facts. So it won't be one size fits all.
We have to remember that the court cases going back for several centuries have always dealt with difficult situations, whether it's the closure of the Suez Canal or the commencement of World War I. There are cases that arise from that. Contracts still exist, still apply, still enforceable. And as Andrew said, you just have to read the terms of them.
So when will parties be relieved of their obligations under the contract?
Well, for COVID-19, there are three basic ways. One would be frustration, the other would be force majeure, and the third, supervening illegality. So frustration is the concept where performance of the contract has been rendered impossible or goes to the heart of the bargain by a supervening event. Force majeure is a contractual term where it is contemplated by the parties that a supervening event will have occurred, and the contract will provide for what then happens in those circumstances. And then the third, the supervening illegality, that's kind of how it sounds, which is a law has been passed that renders performance of the contract illegal.
And what's interesting about COVID-19 is normally as a person who drafts contracts, I'll be saying, don't rely on supervening illegality, because who knows what that's going to be. Don't rely on frustration, because as we'll hear from us, that's typically a very narrow and high bar. Normally, you rely on a force majeure clause. And if your contract has a force majeure clause, you then read that carefully. And that's because of the challenges with frustration and illegality. That's why most contracts have a force majeure clause in it. What's interesting about COVID-19 is it's so massive, its impact, that actually it's more likely to cause truly frustrating or truly supervening illegality in a contract, and therefore might actually be an option, unlike normal force majeures.
Is there any debate over whether COVID-19 is a force majeure event?
There will be quite a lot of debate, but it all depends on the wording of the force majeure clause. Some clauses in certain contracts do actually specifically relate to pandemics and endemics. So they actually do envisage such an event. Others talk about such things as acts of God, which normally most people think of as sort of geographical events such as flood or lightning strikes or whatever. But in theory, at least, although I'm not aware of anything that's been that has truly tested it, the work at a more microscopic level might be an act of God.
And so you need to read your clause. Some clauses, many clauses typically refer to something outside the reasonable control of the parties. But some clauses just have a specific list of events. It might list terrorism, but it might not list epidemics, in which case there's going to be immediately a dispute as to whether COVID-19 will then count. Also, we need to bear in mind that actually COVID-19 itself is rarely actually the event that's had an impact. It's, we're all working from home, not because we've all got COVID-19. We're all working at home because of the measures introduced by the government. and the risks that are arisen. And so that is the actual event. And so you have to ask yourself, what has actually caused this force majeure event? What has actually stopped me providing these services? Is that a force majeure? So if you're a retailer and the issue is about whether or not you can open your shop, well, that's going to be clear because you look at the government legislation that says if you're a non-essential shop, you have to close. Therefore, that's going to be, that event of shop closure is the force majeure event that happens to have been caused by COVID-19.
So as a contract drafter and as a contract breaker, if I can term you that, Andrew, what practical steps can clients take to establish the positions they want to adopt?
So I think from a breaker point of view, I think that the answer to that question is, if you think you have a situation where you think that there has been a force majeure event or a frustration of the contract, the first thing to do is look at the facts. What, as David was just saying, it's not COVID-19 itself. What has caused you to be unable to perform your contract? And that is going to be key. And then you compare that with the contract. So a bit like Sam was saying, you need to get the policy out, you need to get the contract act, and you need to give it a really good look. Compare what is preventing you with what the contract says. Of course, you should just see whether the government has made your performance of the contract illegal, because ironically, although very tough, that makes it easier to prove. And then when you've got your contract out, should look to see if there's a force majeure clause. Not all contracts have them, some do. If it does, it means that frustration is less likely to be relied upon, because the way the courts would look at it, the parties have turned their mind to a supervening event and they have set out what they will do when one occurs. And if there is no force majeure clause, then you're going to have to rely upon frustration if you can. And I would say this, wouldn't I? You need to get some legal advice. This is a big call. To say to the other contracting party that you cannot perform the contract, you need to be certain of the reasons why, and you need to set it out as best you can, because the consequences of just doing it half-heartedly can be quite large in terms of breach of contract.
And in reading that clause, be aware that many clauses have express requirements to notify immediately or quickly. So you can't just sit around. The longer you leave it, the more challenging it's going to be to call the force majeure. There's an implied obligation on the parties, whatever your clause says, to use reasonable endeavours to overcome the force majeure. So you can't just go, ha-ha, sit on your hands and do nothing for the next 3 months. You need to actually think about what could you do to overcome it. The other thing to watch out for is it's not just about the force majeure clause. At the moment, I'm finding people leaping too quickly to go to their force majeure clauses in their contract and not stopping to think about, what about the rest of the contract? You know, for example, if you've got a contract under which you pay somebody to make deliveries for you as and when you ask them to, well, if you don't need them to make any deliveries, then you probably don't need to pay them anything. So it doesn't really matter if it's a force majeure or not. You didn't have a contractual obligation to pay them anyway. So I'm encouraging people to look at the payment mechanism, look at the call off, look at the termination clauses. Do you need to go down an argument about whether it's a force majeure or not? And weigh up the alternatives.
And this question probably for David alone, I'll check in with you, Andy, afterwards. If you were drafting a force majeure clause now, specifically from scratch, what lessons might you have learned from what's happening now and how it's playing out to get the perfect clause drafted for the future? Yeah,
and actually there's learning from hindsight, and then actually about what do you do about COVID-19 now we know it's out in the world. So there's two separate issues there. Lessons learned is, I think this emphasises why a well-drafted force majeure clause that's uses phrase like reasonable control, sets out when you should notify, sets out the consequences. Those clauses are working well. I mean, okay, there's a bit of debate about exactly what they mean, but they are well structured and they provide good signposts to everyone involved. The clauses that aren't working well are the ones that are sort of one line long, don't refer to reasonable control, don't really tell you what happens next. And worst of all are those where there are no force majeure clauses at all, because then you're into this debate about, well, is it frustration? And then leafing out very old cases to work out, well, if it is frustration, what that means. I mean, there's plenty of disputes going to be coming on those contracts that don't have force majeure clauses. And I think people will be glad that those that have got decent force majeure clauses will be glad that at least they're not having those arguments, and we'll be having a narrower set of arguments.
Andy, anything to add?
Well, unusually for me, no. I think David said it all, and even though I want to take lumps out of him, I don't think I can.
maybe that's something for later. I don't know. But
Michael, can I just add one thing?
You may add one thing, David.
In drafting a force majeure clause today, a really massive thing that has now changed is you can't today say that COVID-19 is something you didn't reasonably anticipate. And therefore, if you're entering a contract today, you can't then enter the contract today and then call force majeure tomorrow going, oh, there's COVID-19 stopped me. The courts are using force majeure clauses to protect people against things they couldn't reasonably anticipate. So if you are entering a contract today, you're actually going to have to specifically deal with the impact of COVID-19. And we're starting to see various people starting to draft wording about if in the course of their contract, if COVID-19 impacts and what that means. The problem is the clauses I've seen so far remind me very much of actually the Brexit clauses we saw, is that they're very broad, very vague, very sweeping, and you sort of read them and go, well, this allows the supplier to, at any point in the next 12 months, to decide to stop supplying and have no liability at all. So I think we've got some distance to go before we settle on what are fair clauses dealing with COVID-19 risk in future contracts.
Both of you have probably seen quite a few examples of how all these arguments are playing out. Are there any you can share, sparing their names, of course?
Well, there have been a number of different cases in relation to both force majeure and frustration. Indeed, as David said, Brexit has been the last sort of in thing for that kind of debate. Instead of going through the facts of every one of the cases, I can tell you what the results were, which is pretty much every case of the last few years has ended with the court saying that there was no force majeure event and or no frustration. And one of the reasons for that is, as Sam was talking about, a sort of but-for test. So there may well have been an event, but it didn't cause the failure to perform the contract. The courts are very keen at the moment, well, have been up until COVID-19, I would say, to keep the parties to a contract to their bargain. I have to say, I do think, as David hinted at earlier, we are in a very different world now, as I'm sure we're all feeling. But in terms of the courts and the way it looks at frustration and force majeure, it might have breathed a new life into these concepts. And I think the court might be a little bit more flexible in the future than it has been up till now.
Some of the examples I've seen, one of them is a client who plays a small part in a large industrial process. If they don't do their part, the industrial process will shut down and cost £14 million a day. And there's a gang of 8 people working shifts day and night to do this small job. And so the question was asked of me, well, what happens if they all have to stay at home due to COVID-19? To which my reaction was, well, there's nothing with COVID-19 preventing you from sending people to this factory to do this task. Yes, they're going to need to be taking advice from somebody like Andrew Litchfield about how they can do that safely in the current environment and social distancing and so forth, but you can still send people there. COVID-19, yes, it's having an impact on people, but it's not at the point where the whole population is unable to leave their houses. So I was saying, I think you're going to struggle to find that a force majeure has happened, and actually, therefore, client, you need to take steps to work out how you can manage the risk. If you think there's a chance that 25% of these people might not be able to get to work, then maybe you need to think about recruiting extra people so that you can keep this process going, especially because of the huge liabilities that could arise. So that's on the supply side. On the customer side, again, seeing lots of people claiming force majeure when is it really? So I've got a client with a major company with a back office outsourcing arrangement with a major supplier. The people involved are all household names. The supplier could quite easily do the tasks required from home. Okay, there's a bit of a mobilization of equipping people to work from home, but they haven't really covered themselves in glory. In fact, it's the customer who supplied the laptops to allow the people to work from home so that the service could continue. And so we're already getting into a bit of a scrap about whether the business continuity plan that the supplier's contractually obliged to have and to apply has actually been applied, and whether this actually is a force majeure event, because you could have anticipated this, and you certainly shouldn't take days and days and days to flick over to home working. And so I'm sure people like Andrew Smith are going to be dealing with those kind of disputes for some time. I think overall, the impression I get is force majeure is harder to show than people realise it is. And I think we're going to, as Andrew just said, I think the courts are going to be quite careful to keep force majeure or frustration as a narrow concept going forward. And people might well be surprised in the disputes that they can't use it as the sort of get out of jail free card that some people think it is.
I've been very pleasantly surprised at how resilient certainly our own systems have been with the remote working, where we've gone from 10 miles to 110 miles almost overnight. And my sense is that a number of, well, most of our clients are actually doing a really good job at keeping on business as usual in terms of certainly the sort of legal elements of their business, where that kind of stuff can be done remotely. But at some point, at the end of any negotiation, a contract needs to be signed, of course. What thoughts have you got on how you can just get to that final hurdle in the race with the contract and get our contracts signed off when offices are in lockdown? Yeah, and actually, I could have foretold that we were going to have force majeure questions, but I have to say I wasn't expecting the number of electronic signature questions. And of course, that makes sense because all of a sudden, people are working at home and are not in the office to do a wet ink signature, or certainly not as easily. So I am seeing a lot of questions about that. The good news is that under English law, for normal contracts, and just normal contracts, not deeds, English law is very supportive of all kinds of ways of signing documents. Firstly, bear in mind that a normal common or garden contract actually doesn't need to be signed. It's just that a signature is a nice bit of evidence to show that the parties have agreed to it. And so therefore you can be pretty relaxed within your corporate controls, and that's the main issue. How do you control what is signed or committed to by your company in this virtual world? And so that might be using an online signing platform such as a DocuSign, or it might simply be carrying on signing by printing off, signing, scanning back in, or it might simply be an email going, I agree to this attached contract. Everyone can find their own ways through how best to manage that risk in their organisations. And of course, people should ask themselves whether everything really needs signing. I'm talking about contracts, but of course, many organisations have lots of pieces of paper that need signing. Now's the time actually to challenge whether does it really need signing? The tricky area are deeds, because there are various complicated and archaic rules about deeds and how that fits in an electronic world. We're all at the moment internally debating a recent court case, which was all about a badly executed deed, where the court found the deed wasn't validly executed.
there's no surprise on the facts of that this deed wasn't binding. But what was alarming is some of the commentary from the judge, which suggested that the Standard Law Society guidance on signing deeds remotely may not be enforceable, and therefore people should, where they're signing deeds electronically, should seek specific advice as to whether they are effective, the process they have. Now, obviously, most contracts aren't deeds, so that is a specialist area, but it is one to keep an eye out for.
Well, thank you, David and Andrew, for a quick canter through contracts. Of course, another area where good process and form is important, and COVID-19 causing some problems, is corporate governance. And so I'd like to turn now to Charles Bond, who's one of our corporate partners in London. I mean, as an example, how does a company hold an AGM when the country is in lockdown?
Michael, it's a good question, and it's been asked quite a few times recently, partly because we are now moving into the AGM season for public companies. Most of them will have a year end at the 31st of December and have to hold their general meeting within 6 months thereafter, so by the end of June. So a lot of companies tend to have those around about now, or certainly over the next couple of months. So it's a problem for a lot of companies that they've been grappling with. A lot of the various stakeholder groups have been putting out guidance, so the picture is becoming a bit clearer. But there seem to be 3 things that people can do depending on where they are in their AGM season. If you haven't yet posted your AGM notice, then it's probably worth delaying doing that until the picture is a little bit clearer. As I say, you've got until the end of June to hold that meeting. So people might want to just consider waiting and seeing what happens. There are a couple of issues with that, partly because some companies might want to, in this, although it sounds a bit strange in this environment, to declare dividends. Most companies are either deferring dividends or even cancelling interim dividends that may have been previously declared. So that may not be such an issue, but there are some companies out there who are still paying dividends and may want to do so and not wait until June to do that. The other issue is that companies are also cash constrained, as we can imagine at the moment. And if they need to raise new funds, which we'll come to a little bit later, I hope, then in those circumstances, they need to have the relevant annual share authorities in place to do that. And so if there's any risk that those authorities might expire in the near future, then it's probably advisable that they have their general meeting to refresh that authority sooner rather than later. So that's one course of action, is to delay your AGM. If you've already sent out the notice of annual general meeting, then you can, if the power is given to you in your articles, postpone that. You can notify your shareholders that it is going to be postponed to another place and time. Some companies, they don't have the power to postpone in their articles. So for those companies, all they can do is actually adjourn the meeting at the time it's meant to be held. That may be because nobody actually turns up, there's an automatic adjournment provision in their articles, or it may be that just 2 people turn up as a quorum on the steps of the building where the meeting is meant to happen, and adjourn it to a later date and time. And generally, if you're going to adjourn it for more than, say, a month, then you should be refreshing the notice to your shareholders. So those are the 3 things that companies are all looking at the moment. If you do decide to go and hold the general meeting, then there are some obviously things to worry about. First of all, the social distancing and the government guidelines that unless the business is absolutely necessary, there shouldn't be more than 2 people in a gathering. Clearly doesn't work for an annual general meeting. And I think most people take the view that attendance at an annual general meeting is not essential work. So most people who are going ahead with their general meetings are saying that there only will be 2 people present and that will normally qualify for a quorum under the provisions of the articles, as long as one of them each of them holds shares either in themselves or as a proxy for another shareholder. And companies, if people do attend, they can and do have the power to turn people away. So most companies who are holding their general meeting are now including a set of cautionary wording on the general meeting notice explaining that people should not turn up the meeting. They may not be allowed entry. And in fact, most people are being persuaded to submit their proxy vote well in advance to make sure those are counted. Some companies have also started looking at how you could deal with this rather than as a physical meeting. And so there's been a big debate about different types of meeting, hybrid meetings, for example, which are both physical and electronic meetings, whereby people can attend and vote electronically. That's a hybrid meeting, or a purely virtual meeting where the whole meeting is done essentially online. Many companies have the ability to have hybrid meetings in their articles, but very few have the ability to have a virtual meeting. And that's partly because the law is a little bit unclear around that, because the Companies Act says the company has to notify the place at which the meeting's being held. And if you're having a virtual meeting, then there is no specific place. So a lot of commentators are saying that virtual meetings are probably at this stage not permissible, but it may be. We've had a couple of days ago, a recent announcement by the Business Secretary saying that they are looking at changing the legislation, and it may be that they're going to introduce the concept of a virtual meeting to say that is indeed possible under the Companies Act. Other companies are taking the view that they are going to have the meeting. There'll just be 2 people present, but they will do a webcast of the meeting so people can at least tune into it and hear it, and potentially submit questions in advance to the chairman, which he may be able to answer on that webcast. But again, a lot of the commentators are saying, this is an unusual situation. Companies should, if they do hold their general meeting, think about other ways to engage with stakeholders later in the year when there is the possibility of doing so, possibly having some alternative form of shareholder meeting later in the year. But whatever happens, I think the current situation probably changed, possibly for the good, the way that general meetings are going to be held in the future. I think more and more people now will be looking at more innovative online ways to hold their annual general meetings.
And presumably there are public company issues around filing accounts as well now.
Yes, so there's been some flexibility there as well from the government. Generally, main market listed companies have to get their accounts in 4 months after year end. So they would be, they'd have till the end of April to do that. It's clear from the guidance that's been issued by the FRC that there's going to be significant challenges with home working for auditors to sign off on those accounts in that type of timescale. So there's been an additional 2-month extension for main market companies to get their filings done. For companies on the junior market, the AIM market, they generally have to get their accounts in within 6 months of year end, and they've been given an additional 3 months to get their accounts in. And so accordingly, Companies House have also said they will now accept later filings up to 3 months after the normal timescale. But in each of those cases, the company has to actually apply to the relevant authority for that extension, although those extensions, I'm told, are being accepted on a fast-track basis.
The world obviously, or most of the world obviously now knows about COVID-19, but what sort of announcements do you think that public companies and perhaps other companies need to be making about COVID-19?
I think, well, clearly the world's aware of COVID now, so company doesn't have to announce anything about that in particular, but the normal rules apply. So again, the FCA have said that companies should be aware that they have to continue to comply with the market abuse regulation. If COVID is creating a significant impact on their business or their results of operations, then they do still have to announce that, just as they would do in a normal market environment. So they do continue to have to comply with their normal disclosure obligations. They have recognised, of course, that often those disclosures are determined by disclosure committees, which are part of the board of directors of a public company, and they may have a little bit more trouble getting together more frequently. But overall, the pressure is still on companies to make sure they're making the correct announcements. Some companies may be applying for suspensions of their shares, especially in such a volatile market. But again, the FCA have said they will only look at those in the kind of very rare instance that a suspension is required. Normally, if there is an issue, then it probably needs an announcement, not a suspension. And they also expect senior officers and directors to make sure they're making the correct announcements about dealings. So persons discharging managerial responsibilities, or PDMRs as they're called, still have to continue making their announcements. So to some extent, it's business as usual for announcements by public companies.
You mentioned early on in your piece the need for businesses potentially to reach out for emergency capital. What plans should companies be making in that regard?
Yeah, well, I think everyone's aware that there is a kind of global cash flow problem now. And this is a little bit different, I think, from the financial crisis we had in 2007-8, which was more of a kind of systemic crisis. So there is no doubt that companies with shortfall in capital will need to go to the market to raise more financing. And we're already seeing that happening with the calls we're taking from companies about how they should best go about and structure the type of capital rise they should do. That very much depends upon timing and size of capital raise. You'll probably know that a company can go to the market on what's called a preemptive offer or a non-preemptive offer. Preemptive offer is where it goes and offers shares to all its existing shareholders on a proportionate basis to their existing holdings. And the non-preemptive one is where it just goes and seeks new investors and disapplies those preemptive rights. A preemptive offer is good in some respects in that you can raise a lot of money through a preemptive issue, and there are no specific caps on how much you can raise under the various rules that apply to public companies. The trouble is that they are quite convoluted in the fact that for a rights issue, for example, you probably have to call a shareholder meeting on 14 days' notice, and you also have to publish a prospectus that gets approved by the FCA. And then even once you've got the shareholder approval, the offer period has to be open for another up to 14 calendar days. So you can imagine that's at least a month's work just to be able to get the approvals you need. So a rights issue, I think for the very large companies that are well capitalized will probably be the way they go. And that's certainly what we saw after the last financial crisis. There were probably 3 or 4 times as many preemptive rights issues that year than there had been in previous years. There are alternative structures, for example, what are called open offers. An open offer is similar to a rights issue, but your shareholder who doesn't participate doesn't get the difference between the offer price and the subscription price. The lazy shareholder gets no rights, unfortunately. So open offers are a little bit more aggressive, and they are shorter in timetable as well. They only need 14 days to conclude. So those can be a little bit better, but institutional shareholders will always prefer a rights issue. And then on the non-preemptive side, there are straight placings, so companies can go straight to the market and raise funds from new investors. Those are great, but you tend not to raise as much money through a placing. And they do depend on the company having disapplied the normal preemption rights. in times of need, if people really need money quickly, there are ways to circumvent a normal placing and the preemptive issues with something called a cash box placing, which I won't go into in detail, but is just a way of issuing shares for non-cash consideration. And in those circumstances, you don't have to apply the preemptive rights rules. You basically set up a special purpose vehicle in Jersey and you issue shares for non-cash consideration. Those I think we will see arise, and we're already aware, having spoken to the offshore lawyers, that there are 5 or 6 instructions going around the city on those types of cash box placings. And then finally, you can combine these types of issues, and I think one of the structures we'll see them combined with is convertible debt. Convertible debt offerings such as convertible bonds give companies quite a lot of flexibility to raise a large amount of money, and offering a high coupon in today's very low interest environment can be attractive to investors. And if you can also make sure that the conversion of the debt is not until kind of later in the year when share prices are more stable, that may well be more attractive to the company as well. So I think all of those types of new share issuings or debt or convertible issuings are going to be attractive. Each company will have to look at the various options and decide on its merits which is best for it. But I think probably the biggest issue will be getting to the market first, because the limit, there is a finite market there for cash, and in certain overcrowded sectors like retail or aviation, for example, where companies really need that money, I think it'll be a very crowded marketplace. So the quicker people get to market, the better.
Thank you, Charles. Businesses are all over feeling stress in these environments, and clearly the present situation presenting huge challenges for most businesses. Julian, you're one of our partners, an expert in restructuring. How do directors ensure that they discharge their duties in the current circumstances?
Well, thank you, Michael. The short answer to that is with great difficulty. Directors, we hear that healthcare workers are on the front line and fighting COVID-19, and of course they are, but directors have got an equally important job of keeping the wheels turning, helping to minimize the damage to the economy, protect the livelihoods of their employees, and keeping otherwise viable businesses intact so that they're still around after we get through this. Directors are under a broad range of obligations and duties under all sorts of statutes and regulations. We've touched on quite a few of those already this afternoon, probably enough to scare most directors, and most directors might be thinking the easy way out is to resign, but unfortunately that won't do the job because they're still under an obligation to do their best for their companies. And I think the problem really is that even in normal times, there's a tension between the general duty of directors under the company to promote the interests, success of the company for the benefit of its members generally, but also to take into account a number of other factors, including the interests of suppliers and customers, employees, and business relationships, and the long-term effect of their decisions. So there's already an inherent tension in directors' duties. In addition, in the current circumstances, directors are going to have to perform a very, very careful balancing act, because they're going to have to take some short-term decisions around prioritising critical payments, minimising discretionary spend, protecting their workforce and so on, which may have a potentially detrimental effect on the long-term impact of the company's financial trading position and its finances. The other problem we've got, of course, is that once solvency of a company is in doubt, or insolvency is possible, and for that you probably should read insolvency is probable, and you might say that for most companies at the moment, insolvency is certainly possible and almost certainly probable. The directors have an additional duty which overrides all the other ones I've talked about, which is to protect the interests of creditors. We then come to what I think is a central issue for directors at the current time, which is that the government's approach to this, no doubt done with the best of intentions, and admittedly it's all been done on the hoof because nobody's had to do this before and nobody's had to do it at this speed before, is that it's a sort of almost a sort of schizophrenic approach to the problem. The government has made big grand gestures about putting a lot of liquidity into the market in terms of support to companies, support for employees on furlough, VAT and tax deferrals, rent holidays and things of this nature. But at the same time, they seem to be expecting a lot of companies simply to go into hibernation because they're having to close their doors, they're having to shut their premises, their staff are being told they can only go out if it's essential and all the rest of it. And so we've got this contrast between the government saying, here's a load of liquidity so you can keep paying your liabilities they fall due. But on the other hand, we want you to shut up shop. And also we'd like you still to be around in 3 months or 6 months' time. And there is an inherent tension there. So that creates a huge amount of problems for directors trying to navigate their way through this minefield of potentially conflicting duties.
The government's announced, I think, a suspension of the rules relating to wrongful trading and a moratorium for creditors. Is this going to help?
A bit, but not a lot, unfortunately. The suspension, first of all, of the rules relating to wrongful trading. Well, wrongful trading is a specific concept under the insolvency legislation, which enables the courts to fasten personal liability for directors on the directors for the liabilities they incur in certain circumstances, which is a sort of cuts across the principle of limited liability companies. And the circumstances are where directors continue to trade at a time when they know, or they ought to know, and this is always judged with the benefit of hindsight, that the company has reached a point where there's no reasonable prospect of avoiding insolvency. Now, in the current circumstances, of course, it's probably the case that certainly with hindsight in 6 months' time, it's going to be possible to say that a good many companies have already reached a point where there's no reasonable prospect of avoiding insolvency. So what they're saying is, don't worry about that. We'll take away that sword of Damocles around wrongful trading. So don't worry about personal liability for carrying on trading. And of course, that chimes with what I said earlier about the government wanting directors to try and find a way through this and hold businesses together where they can. But, and this is the big but, they haven't suspended any of the other rules or talked about suspending any of the other rules relating to trading while insolvent. So first of all, directors still can be personally and indeed criminally liable if they trade fraudulently, and that's where they incur credit knowing that they won't be able to pay it, or completely recklessly without regard as to whether they can pay it or not. Secondly, misfeasance, breach of directors' duties, they're still going to be liable for that. And things like preferences, giving preference to certain creditors over others, or transactions are undervalued, all those rules will still apply. So the directors still need to be aware of their obligations and duties in relation to trading while insolvent or potentially insolvent, and guard against falling into any of those other traps while they do so. Moratorium's a more difficult one. We already have the possibility of a moratorium under an administration, which prevents creditors taking action against a company when it's in administration. And clearly at the moment, first of all, the government doesn't want thousands or millions of companies to go into administration. They want companies to survive. Secondly, actually from a practical point of view, it's going to be very difficult for insolvency practitioners to run many administrations. You know, getting staff out on the ground to man premises, to get control of records, to get control of business is going to be very, very difficult. Some of the reasons we've already talked about today. The moratorium that they're talking about now, there's two types of moratorium, and in the case of both, we yet have no real detail. The first is a very specific moratorium for COVID reasons. Now, the idea of this is that companies will be able to, in some way, file that they've gone into a moratorium to protect themselves against creditor action in the short term because of COVID-19. And that could be quite a useful tool. because that will help this idea of putting companies into some kind of holding pattern for at least a few weeks or maybe 2 or 3 months or so, whilst people find a way through this mess. But we don't know the detail of that yet. The second is a more formal kind of moratorium, something short of an administration, which has been on the stocks for some time. And the government's talking about bringing that forward now. But again, we don't know all the detail and when that may happen. But again, it's quite difficult to envisage how, in the current circumstances, we could put thousands of companies in the UK into formal moratoriums with the way in which businesses are operating at the present time. So it's very difficult at the moment to see quite how that will work.
So looking at the short term, if you were a director just focusing on carrying on business, what would be the key things you'd be focusing on?
Well, I think there are a number of things directors can do just to get some structure to the way in which they respond to these very difficult circumstances and rise to some of the challenges we've already talked about this afternoon. The first thing is absolutely stick to the principles of good governance. Hold regular board meetings and don't treat them as a mere formality. Make sure you have good collective decision making and base it on good, up-to-date factual evidence, trading results, forecasts, and make sure that that's reviewed continually, and you review your decisions and update your decisions on the basis of changing circumstances. The next thing I think is really important is the directors must be aware of the available support, both in terms of the things on offer from the government, the business interruption loan scheme, the liquidity support for larger companies, VAT and tax deferrals, the furlough scheme we talked about earlier, rate holidays for business rates and things of that nature, and various forms of grant. Directors should really go out there and find out what's available and make sure they understand the terms and whether it's appropriate for their business. And also in terms of support, professional advice. I mean, we would say this, wouldn't we? But actually, different companies have different degrees of internal capability to deal with something like this. But in all cases, it will not be wrong for directors to reach out and take appropriate support from lawyers, from accountants and other professionals to help them navigate through and make robust and responsible decisions. Third thing is engage with stakeholders. I mentioned earlier that there's not been much intervention by the government to change rights, private rights in terms of contract. So things like leases, rent payments, contractual payments. We've already talked earlier today about the problems under contract. Engage with your stakeholders, because it may well be that it's not in their interest not to reach agreement with you about deferring rents or deferring loan payments or reducing pension contributions to pension schemes in the short term. They may have a mutuality of interest in seeing the business survive. But in order to get to that point, you need to engage with them and make sure that you keep them on the same page so they go with you on the journey. Insurance, we talked about. Sam's talked a lot about insurance. Make sure you know where you are with your insurance, that it's up to date, that you've got your directors and officers insurance in place when you're thinking about directors' duties. That's clearly very important. And then I think the audit trail, make sure you keep notes, keep minutes of your meetings, keep notes of your decisions and the reasons why you take decisions, that obviously the advice you take and all the rest of it, because inevitably a lot of this will be looked at sometime in the future with the benefit of hindsight. And whilst I'm pretty sure that the courts are not going to be taking directors who've acted honourably and properly in the interests of their stakeholders, their employees and the wider community to task, they are going to be looking out for cases, and sadly there will be cases where people abuse the situation or act dishonestly, and they will be looking out for that. So directors should keep the audit trail, both in terms of formal board minutes, but also notes, memorandum of meetings, decisions, and so on.
For some businesses, it feels a bit specious to talk about the longer term, but is there anything directors ought to be thinking about now for the longer term?
Well, yes, I think a number of things. I mean, clearly, we all hope to get through this and to come out the other end. And at some point, directors can be planning meaningfully for what that's going to look like. But as we go through this, I think, first of all, directors should, as I mentioned earlier, keep things under constant review, keep adjusting their decisions, changing direction if necessary in response to changing circumstances. And we've all seen things move very quickly in the last few weeks, and none of us could have predicted 3 or 4 weeks ago where we are today. Secondly, do plan ahead based on what you know today, based on the information you've got, your latest forecasts, your latest trading results, your latest cash forecasts, and also what you're able to agree with your third parties, any deferrals and so on. But do remember that if you defer tax, if you defer rent, defer VAT, it's going to catch up with you at some later point. So you need to be planning ahead for that wave that's going to come later on, which will hit liquidity. So even if you manage your liquidity now, you've got to be thinking about how you're going to be managing it in 12 months' time as well. And also plan ahead when we come out of this. We probably will see in many areas a bit of a mini boom. And classically, this is where businesses do fail because they'll need additional working capital. Otherwise, they'll run into the risks of overtrading. And then the other thing I think directors need to think about is that as we get into that kind of period, there'll be increased counterparty risks. So not only do you have to protect your own business, you need to think about the downside risks of your suppliers and your customers failing. And that'll be bad enough during this period, but as we come out, that could be even worse. So plan ahead for that. And then I think also think about how you can rebuild relationships. Inevitably, some of the short-term decisions, I mentioned earlier, there's this balancing act between decisions you have to take in the short term just to survive, but the potential for longer-term damage to relationships with employees, with customers, with suppliers, with financiers, and so on. So managing those relationships for the future is also very important. And don't make assumptions. I mean, I think the one thing we've learned more than anything so far in all of this is don't assume anything. So be prepared for the unexpected so far as you can.
Thank you, Julian. I mean, government and government policy has clearly been very much to the fore of late. And I'd like to turn now to Bernadine Atkins, very much the Gowling darling of the BBC, I would like to say, and perhaps Sky as well. It seems to have rubbed off as you are sitting there in front of your library, as many a BBC economist has been doing over the last few days. But there's been a fair amount of comment and confusion in the mainstream media about state aid, including even the suggestion that the proposed support for industry from the UK government might be illegal under EU state aid rules. Is that fake news, or what's the truth, Bernadine?
Yeah, fake news, Michael. The Commission has moved extraordinarily fast in terms of giving guidance and clarity to what will be permissible state aid. And from early on, the Commissioner in charge of state aid, Margaret Vestager, said that we recognise that it's absolutely appropriate for governments to be giving public support. And really what the Commission has done is stood back to allow member states to do what they need to do. And in that context, they've issued what they've called a temporary framework. Already before that, they'd rubber stamped Denmark paying what seems like chicken feed now, just €12 million, euros. And the temporary measures, they've been agreed with the member states, 19th of March, and essentially the Commission's been very clever. It says, we have here what is called exceptional circumstances. And only, I think, to my knowledge, twice before have they ever said earmark something as exceptional circumstances warranting state aid of this nature for the Icelandic volcano and for 9/11 vis-a-vis insurance and aviation. And this means that the Commission has no discretion. It's absolutely, if state aid falls into that bailiwick, it simply has to wave it through. All the member state has to do is to demonstrate that it's within the parameters of the need to address the disturbance as a result of those exceptional circumstances, and it is waved through. The Commission still needs to see it. So the Commission has indicated for certain sectors specifically affected by COVID-19, they will fall into those circumstances, such as travel, tourism, are two obvious areas, and hospitality. Now, the other areas, it's much more fluid. The Commission has a discretion whether to clear the aid, and that's with respect to where they say this sort of aid is to remedy exceptional circumstances, remedy a serious disturbance. And historically, the Commission rarely used that particular label, but since Lehman Brothers, that really did open the floodgates. Since before that, we had free med decisions. Since Lehman Brothers, we've had 400 decisions under that label. And so now the Commission has indicated it's basically set out the basis upon which it will wave through specific measures. And so far, it's waved through about 10 different applications from 10 different member states. And the numbers are eye-wateringly high. The UK is included in that initial wave. I mean, 654 million, that sounds high. That's for small and medium-sized enterprises. That's the UK government clearance so far. But if you compare it to Germany, for example, offering 1 billion euros per company in the form of subsidised interest, and there's France also with subsidised loan offering 300 billion and getting clearance for that. The numbers are pretty huge. So I would say to companies, if you are in recipient of state aid right now, it's imperative to keep proper records. Things are moving really, really fast. And in later months and years, people may look back and try and work out who said what to who. Is this legal? Is this illegal? It's imperative companies keep good records. And whoever's in charge of the record keeping, if they leave or move on, that role is passed on to somebody else. Because that is obviously experience companies have had in the past of not maintaining those records. And also keep an eye on what is happening. This is a moving landscape. With Lehman Brothers, I think the Commission issued 3 differing communications as they gained in learning as to how they would use their discretion. The situation is different here. It's actually less complex. With Lehman Brothers, the crisis there was a systemic problem with the banks, and there was a worry about moral hazard. If we give them more money on top of their mistakes, there's a problem there. Here, this is very different situation, so it may be much more straightforward. But that is certainly what I would do to say to companies: is keep records, monitor the situation.
What does seem to be good news is that there's some easing of UK competition rules, certainly most notably in relation to groceries and the supermarkets. Is competition compliance one less thing for business to have to worry about now?
I wish I could say yes, Michael, but you wouldn't accept a competition lawyer to say that. Yes, it's true that the CMA have issued a communication, but they've basically said, we are not, our priorities are that we are not going to investigate where companies cooperate together if it is something that is necessary and appropriate to address a possible shortage, if it's in the public interest, if it's to the benefit of consumers, if this is something that is critical, that has arisen because of COVID, and if it's temporary. So you can see straight away there's lots of wriggle room there for the CMA if it sees something it doesn't like. But what we have also seen, which is I think largely good news for supermarkets, is what, again, exceptional circumstances, what was as a few months ago some very, very obscure part of the Competition Act, Schedule 3, Clause 7. Who knew? The dust has been blown off it, and the government have issued 3 statutory instruments, one of which is directed to retail grocery chains and suppliers to that grocery chains, essentially setting out circumstances when they can cooperate together to address the shortages and demands and challenges currently facing the sector, which includes logistics providers to supermarkets for refrigeration, for example. So that coordination is things like coordination on stocks and supplies, coordination as to how you should limit purchases, so how many toilet rolls can people buy or pasta packets, they can coordinate on that, and opening hours. But what still remains a total no-no is around coordination on costs and pricing. And again, this needs to be limited. You need to inform the CMA of what the nature of that cooperation is. Mercifully, it looks pretty light as well. So again, I'm afraid it's not a carte blanche, but obviously permission, but within certain careful boundaries. So people, again, I would recommend monitor, document, tread carefully.
And what about the old chestnut of abuse of a dominant position? Do businesses need to be wary of that as well?
Yes, absolutely, absolutely, more so than ever, because the old standard, what I always call the Mickey Mouse approach to competition law, is first find a market, then look at market share and worry if you're over 40%, 50%. In this exceptional market circumstances, the whole dynamic changes. Now you're looking at a situation about market power, where one supplier has a power over another. This position of a French notion of partenaire obligatoire, an obligatory trading partner. So in circumstances of scarce supply, somebody can have absolute reliance upon a supplier. And we can see that already, for example, with respect to the, tests with the chemical reagents. Reagents is now a serious shortage of those. So there you could see that a situation of dominance can arise as a result of this crisis. And both the European Commission and the CMA and other authorities have indicated, we are watching suppliers. If they become into a dominant position as a result of this, these challenging circumstances, we are going to keep an eye on price gouging. Is there somebody are there any people who are now excessively pricing or unfairly refusing to supply or behaving in a disproportionate or discriminatory fashion? We are watching. And that is an area where people, if they are in that situation, of either having that dependence or conversely, being in that situation of market power, they need to tread carefully, or if you're on the wrong side of that relationship, do something about it, get on to competition authorities, because all of them have clearly indicated that they want to move fast vis-a-vis such abuses.
I can't think of a conversation with you, Bernardine, over the last couple of years, I would say, where the B word hasn't come up. Obviously not Bernardine, but Brexit. What on earth is going to happen to the transitional period?
Yeah, I think this is just a warning to people. I think the rational person would say, surely, we are not going to have the end of the transitional period coming in December. Surely we will all need time to negotiate this beautiful free trade agreement that we're going to get at the end of this situation. Because at the moment we're in this fiction. We've left the EU, and so everybody is playing, let's pretend we're still in the EU. And all of that, the music stops in December. But so far, all the signals from government and the politicians are that the music will stop in December. And I do warn industry, no matter what people might be saying or the lobbying that is going on, that seems to be still the clear signal. So I would say to industry, painful though it is to hear, despite the dislocation of COVID, people still need to prepare. And I'll do a quick shout out for myself and Ursula Johnson, who's our head of customs. We've done a webinar on basically how to prepare for Brexit from your back bedroom. Because there's a lot that in-house counsel can do remotely, and there's an awful lot of money that they can save their internal client if they start to get systems in place now. So I'm sorry to say there is absolutely still no room for complacency on this, because we may get a really skeletal free trade agreement, the bare bones for December, and then there's an awful lot of things that are kicked into the long grass following forward. But all the indications are that the government wants this to happen in December.
Well, Bernardine, you obviously haven't absorbed the BBC's rules about on-screen advertising there about your own seminar, but thank you very much for your quick canter there. Now to the audience, I hope you have found the review of some of the key issues arising from the COVID-19 crisis both interesting and practical. And I'd like to say on my behalf a big thank you to all the speakers who have taken the time out to deliver the presentation. I've certainly found it very interesting, and every one of them is still with us and doing their very best to look very interested in what everybody has said throughout the entire hour and a half. They've done an incredibly good job. Please feel free to circulate, I don't know, this is not really a webinar, but this recorded seminar. And if you are interested in more detail, please contact your Gowling client partners, or even directly the rogues you have seen today, who will be happy to discuss their topics in more detail. Our Gowling WLG website landing page, the headline item there provides access to our online COVID-19 resource hub, which addresses these issues and indeed a much wider range of issues connected to the crisis. If you're able to find time please provide us with feedback to how this has gone. We are considering additional events, and we may do it in this format as this crisis unfolds, including those based on sectors and perhaps how businesses might prepare as we see the crisis coming to an end. Until that point, from all of us here, we wish you well. May you and your loved ones stay safe, and goodbye.